our last bill of the day, 1620, and we're going to start with staff briefing.
Good morning again, Madam Chair and members of the committee. For the record, Patrick Moore. Engrossed House Bill 1620 revises and sets new limitations, Engrossed Substitute House Bill 1620 revises and sets new limitations, requirements, and guidelines for courts that order parenting plans in dissolution of marriages or domestic partnerships and legal separation cases. As background, in dissolution or legal separation cases, the court must establish a parenting plan that provides for the care of any minor children. In establishing a parenting plan, the court is either required or allowed to impose limitations based on certain conduct of the parent or a person with whom the parent resides. There are presumptions against ordering that a child have contact or reside with a parent who has committed certain acts or who lives with someone who has committed such acts. These presumptions may be rebutted and overcome by presenting certain evidence to the court. Under Engrossed Substitute House Bill 1620, provisions of law governing when a court either must or may impose limitations in parenting plans are reorganized and revised, and new definitions are added. Specific provisions are established addressing cases that involve allegations of child abuse or domestic violence, together defined as domestic abuse in this bill. In cases with allegations of domestic abuse by both parents, courts must hold evidentiary hearings and make findings to determine which parent poses less risk to the child. Where a parent has engaged in certain conduct, such as abuse, domestic violence, and certain types of assault, parenting plans cannot require dispute resolution processes other than court action, nor may they require mutual decision-making or that parties share the same space, physical or virtual, for alternative dispute resolution. Several rebuttable presumptions in current law are removed, but some remain, such as when a parent resides with a person who has been found to have sexually abused a child, there is a presumed risk of abuse or harm in granting residential time to that parent. Provisions in current law that allow a court to not impose limitations when it finds that no harm or little risk is posed are removed. If a court grants residential time to an abusive parent, it must make specific written findings regarding the factors considered that rebut the presumption of risk of harm. The Administrative Office of Courts is requested to develop training and education for judicial officers regarding trauma-informed resolution and best practices in family law proceedings involving contested parenting plans. A fiscal note has been requested. This concludes my briefing. I'm available for questions.
Thank you so much. We do have a question from Senator Fortunato.
Under the bill, the way it is right now, is this eligible for any federal funding or cover cost of training?
Thank you for your question, Senator. The bill itself does not mention federal funding, but as far as the broader question of eligibility in general, I would need to look into it and get back to you.
Thank you.
Thank you so much for that. Any other questions for staff? Okay. Thank you for that, Patrick. And with that, we're going to move to our first panel. We're going to hear from Judge Monica Carey and Karen White, who are present in person, and we will hear from Mary Welch, who is available remotely. Good morning, Judge Carey. Please do introduce yourself and begin. And staff, given the number of testifiers we have, we're going to ask for a 3-minute timer. And we haven't used a timer all day today, so I just want to say it goes green, yellow, and red. When you see the yellow, start wrapping it up, and when it turns red, that means you need to stop. So good morning, Judge Carey.
Good morning, Chair Dhingra, Ranking Member Holy, and members of the committee. I'm Trial Court Judge Monica Carey.
And I'm sorry, Judge Carey, can I have you just move the mic right in front of you? Perfect.
Thank you. Good morning. All right, I'm Trial Court Judge Monica Carey, and I've spent 20 years in family law and over a decade volunteering with victims of gender-based violence. I left private practice to join the judiciary after witnessing the practical impact of judicial discretion on my former clients. What I've learned is that judges are acutely aware of the responsibility resting on their shoulders. Judges want to make the right call, and judges welcome guardrails for judicial discretion in custody dispute. The original 1620 does just that. It provides clarity to existing laws And more importantly, it creates a structured roadmap for judges to consistently explain our thought processes, our reasoning, and our conclusions. Our explanations provide critical transparency and decision-making that ultimately helps individuals in either accepting the outcome or seeking an appeal. The bill passed in the House will likely create inconsistency or confusion, especially for unrepresented parties. This could delay resolution, which create the need for more court appearances, and in turn interfere with employment obligations. So for these reasons, I'm asking that you pass the original bill, not the bill passed in the House. Thank you for your interest in this bill and for the opportunity to testify today.
And thank you, Judge Carey. I actually do have a question for you. And thank you for all the work you've done in this area. I was greatly concerned about the fact that the issue around mutual allegations of abuse was added in the House. And I was wondering whether you could speak towards that. I don't know if that's more appropriate for some of our other advocates. And then the other question that I had was regarding abuse of litigation. Mm-hmm. And, that is something in my 30 years of working in gender-based violence, I have seen repeatedly happen by many times the abusers who actually have access to more resources than the survivor does. And I'm wondering whether you can, as a judge or in your other capacity, talk about the fact that that has been removed from the House version.
Thank you for the question. And regarding the mutual allegations piece, I do find that to be an area that could be very problematic for litigants as well as for judges and attorneys, and especially unrepresented parties. Unrepresented parties, particularly who are survivors of domestic violence, can come across in a way that can be misperceived. I mean, often in custody cases, both parties have made flaws in their judgment, and how that can be perceived can be pretty confusing, particularly in this complex and dynamic area of law. Additionally, the requirement for an additional evidentiary hearing, I think, creates some confusion. It could pose some inconsistencies with the civil protection order hearings that people have, especially for unrepresented parties. I think the abuse of conflict, because I believe there are other people who are probably going to testify more fully to that, but I would also agree that that is another one of these areas where there's a lot of room for error and subjectivity.
Thank you so much. Go ahead.
Thank you. Good morning, Chair Dingra and members of the committee. My name is Karen White, testifying for the Washington State Coalition Against Domestic Violence. I spent 25 years working in direct services for DV survivors, and in that time, I worked with my team to support hundreds of DV survivors every year navigating the family law and child custody system. I also happen to be a DV survivor who experienced a contentious custody case of my own, and I understand fully what is at stake for children and survivors in the family law system. When House Bill 1620 came before the Civil Rights and Judiciary Committee, I testified in support of that bill. Unfortunately, due to the sweeping changes that have been added, I am here today to ask you to not pass the bill in its current form. Of particular concern is that the abusive use of conflict section of the bill has been removed. In 2024, the American Bar Association paper for Family Law Quarterly detailed the harm that comes to domestically abused parents and their children when courts do not focus on evidence that includes assessing patterns of coercive control and abusive use of conflict. The original version of House Bill 1620 included abusive use of conflict as an evidence-based approach to ensuring that reform to family law legislation is attending to the scope and complexity of these cases. Additionally, the floor amendment language to this bill is structured in an either-or approach. Such binary language does not take into account the complexities that different people bring with them into the family law system, and it takes away survivor choice if a survivor wishes to access alternate dispute resolution processes. It does not acknowledge that because of social and cultural biases in some communities and identities would be further harmed by a binary-only approach. House Bill 1620, as it came out of the Civil Rights and Judiciary Committee, represented years of work with survivors, attorneys, and judges to craft a nuanced bill that best serves children and families. It's a meaningful improvement on parenting plans as they are now and balances the needs of a wide cross-section of survivors. It will provide better guidance to judges and make it easier for survivors who lack legal counsel in its original form. So we ask that you restore the language of the original bill and pass it out of committee. Thank you.
Thank you, Judge Fortunato. I'm sorry, Senator Fortunato.
Thank you, Madam Chair.
In a legal
So
degree to be a judge.
your concern is the removal of the abusive use of conflict
That is one concern,
from
yes.
the version that passed the House, but it passed the House like 86-7, I think. So this is near and dear to my heart because my daughter went through a situation that was not very nice. But we've had examples of the using the abusive use of conflict, basically weaponizing it, and against typically the spouse that has the children. An example was a mom took away the kid's Xbox because he was playing Xbox at 11 o'clock at night with his father. And the court then ruled that was abusive use of conflict. The kid, it's 11 o'clock at night on a school night. And the court sided with the father and in that situation. So we're seeing more and more cases where this abusive use of conflict has been weaponized. And so that's a concern to me. So I'm not, I kind of like the fact that it's been removed.
Yeah,
But,
I think using that term in the context of coercive control as it was added to the RCW when it comes to domestic violence cases, so that there is a contextual element to that. I believe that the language of the original bill did give that contextual element to help clarify what the definition of that is in the context of a family law case. I think there was also other language in there that attested to supporting a protective parent's ability to parent in a way that was healthy and protective. And so, there's always an opportunity to hone that language, but that terminology as defined within the context of coercive control and a pattern of domestic violence does have a particular meaning, and taking away an Xbox is like not that meaning, right? But the language in context is in there to protect against those abusive partners who bring someone back to court over and over and over and over. And in this paper from the Bar Association, it also calls out that that kind of pattern of behavior is a risk factor when it comes to predicting future risk of harm. So there is a particular technical definition and context for that language.
thank you.
Thank you. Thank you. Thank you so much. And with that, we're going to go to Mary Welch. Please do unmute and begin. And the next panel is going to be Brandon Williams, Tamara Emerson, and Shira Cole. And I do believe Tamara is going to be virtual. So you guys can start making your way over while we hear from Mary Welch.
Good morning, Chair Dingra and members of the committee. My name is Mary Welch, and I'm a statewide advocacy counsel at Northwest Justice Project, Washington's largest civil legal aid organization. We provide advice and representation to thousands of clients every year. NJP opposes this bill in its current form because it contains provisions that raise red flags and cause harm to survivors. My entire career, I've been a legal aid attorney, and for the last 18 years, my work is focused on family law and domestic violence work. I've represented survivors, both adults and children, who are victims of physical and sexual abuse and other traumas. I've helped them at all stages of the proceedings, up to and including court hearings and appeals. Now I help and strategize with NJP's more than 40 attorneys who work on family law and domestic violence issues across the state. Working with survivors, trying to help them be safe and keep their children safe is what I care about. This isn't a job to me. In its current form, this bill will not keep NJP's clients and other survivors safe. It will not protect them in the court system. It won't keep their children out of harm's way. Almost 3 years ago, work groups involving DV advocates, DV survivors, legal aid providers, judges, and others started meeting to revise RCW 2609191. 2609191 is extremely convoluted, hard to read by judges and attorneys, let alone unrepresented parties. We came together with the purpose of simplifying the law and making it easier for unrepresented parties to navigate. And the vast majority of people who go through family law proceedings are unrepresented. This version is not simpler. It's a patchwork of provisions that are still confusing. There are new definitions that are unnecessary and have the potential to cause additional problems. And I was frustrated to see that some definitions have been removed from the previous language that would have protected survivors in contentious court proceedings. There are several provisions that concern me. One example is that this bill disempowers survivors by not permitting them to engage in the dispute resolution process if there is a limiting factor found. This is required even if the survivor wants to use that process. Their choices were limited while they were in the abusive relationship, and they're being limited again by provisions in this bill. Northwest Justice Project does not support the language in this bill, as it will harm our clients more than it will help them. Please restore this bill to its prior version. Thank you.
Thank you so much, Mary, for your testimony. You pointed out something that I was concerned about was the dispute resolution process, where this bill actually says that you cannot designate a dispute resolution process. And in all my years of working with survivors, what I found is, like you said, many of them don't have representation. Would that then force them to get a lawyer and go through a judicial process instead of many times the more affordable and available dispute resolution process?
It would require them to go through the court process, either represented or perhaps unrepresented, while, as you said, many times the other party may have more resources and would have an attorney, so they're basically unrepresented against a represented party. Unfortunately, there are not enough resources for Northwest Justice Project to represent all of the people, even a small portion of the people. We represent who we can, as many people as we can in court, but that still leaves the vast majority of people unrepresented out there.
Thank you so much. Go ahead. Yes.
I am Tamara Emerson, and good morning, Madam Chair and committee members. I was a U.S. Coast Guard wife. I know you served, so thank you for your service. And I found myself in Washington State seeking safety through the family court system. As I searched for additional legal help, I found no domestic violence organization provided representation in family law trials. My husband disclosed his sexual fantasies about our 1- and 3-year-old. To me, to investigators, to counselors, and to the court. Our child later disclosed abuse in their own way at age 4. At trial, every expert that testified that my ex-husband had sexually victimized both children. Despite this, the court dismissed all evidence and expert testimony. He had gone through an 18-month rehabilitation for perpetrators program, risk program. At trial, this is when 191s come in. So I have 2 parenting plans. You're welcome to look at them.
Yeah, we actually don't allow documents being shown, but
Okay.
please email them to us, and
totally.
then we will have those.
Sure. So at trial is when you get 191 restrictions. That's what factually we're talking about today. And in 2019, I had abusive use of conflict entered against me for reporting as a 4-year-old continually told me things over time because I never prompted him to tell me. Under Section 1, subsection 3E of this engrossed House bill, this is the .187 best interest of the child provision that it moves from the abusive use of conflict from a discretionary finding that the court can make to a best interest of the child finding. So the abusive use of conflicts under the engrossed bill is abusive use of conflict by a parent who creates the dangers of serious damage to the child's psychological development. This would not be weaponized against protective measures or other things. So it is in there. It's just under a different section, and it's not discretionary. It's under the best interests of a child. As a not attorney and no legal experience, I really understand the engrossed House bill, and I've had other people that have no experience in family law, and they're understanding it really well too. I also represented myself for a couple of years too. During the time that he was awarded 50-50 custody, he reoffended. The Coast Guard found him guilty of raping our child. And engrossed House Bill 1620 is about fairness, but most importantly, it's about children's safety. I now have another parenting plan that the court did find him that he did assault our child. And I'm asking you, read this. This protects children. It gives a pathway that we cannot be punished for trying to protect our children. It's fair, it's consistent protection for safe parents and not punished for reporting. Passing this bill makes child safety top priority. Custody decisions ensuring courts apply a consistent evidence-based approach.
Thank you. I'm going to need you to
Thank you.
wrap up. Thank you.
Thank you.
Okay. Shira, go ahead. And then a last call for Brandon, who doesn't appear to be in person or on Zoom. Go ahead, Shira.
Thank you, Madam Chair and members of the committee. My name is Shira Cole. I'm here in strong support of this bill because it removes the non-abuse factors from the statute, such as the factors you're hearing about today. These non-abuse factors are routinely weaponized against abused children and parents. I have personal knowledge of at least 50 cases where these non-abuse factors are being manipulated as such. Imagine being arrested for nothing, and your abusive ex is the prosecutor and labels anything you do or say as a crime. Only instead of going to jail where at least you're safe, your child is forced into living with a violent, angry person. The more you try to protect your child, the more you and your child are punished. If you're of color, these non-abuse factors are a direct avenue for racism to operate without being detected. It's walking on eggshells. It's court-sanctioned child abuse. This is how non-abuse factors play out in family court. Worst case scenario, your child is killed or raped by that abusive parent. Best case scenario, they only survive a childhood of abuse and or learn abusive behaviors. On March 13th, our Coalition Against Domestic Violence sent out a flyer to their email list, including most of their 70 member orgs to sign in con to this striker bill. That flyer contained not one bit of accurate information. I'll correct some misinformation right now. Abusive litigation is still intact, has its own chapter. And I welcome an amendment to reference it in this bill. Coercive control is not in the abusive use of conflict definition. It is in the DV definition. The bill shows how to solve mutual abuse allegations. It does not label the case as mutually abusive. The dispute resolution provision is unchanged. It's debatable whether a survivor can opt into it, but I welcome an amendment that allows the survivor to opt in. It only bars the judge from requiring the survivor to be in it. Abuse has no excuse. Non-abuse factors have no place in a statute designed to protect children from abuse. Judges have repeatedly failed to protect children. Judges are the ones who need to be limited, and that is what this bill does. Judges have no right to testify against this bill. What do they have to lose? They have to actually do their job right. I beg you to listen to the people who actually have their children being held hostage in this toxic system. I'm happy to answer any questions. Thank you.
Thank you so much. Senator Fortunato.
Good to see you again.
Me too.
Do you know that both of you guys signed in con?
So they signed in pro, Senator
pro.
Fortunato.
The original bill was completely stricken.
Right. So, but I think you're listed as con now, so you may want to change it.
No, they're listed as pro.
I think it's on the briefing because it's from when it was the original bill.
Yeah. Thank you for pointing that out because that's our testimony from the House.
Different.
Yeah, thank you.
Thank you. Our next panel is Judge Janet Helson, Elizabeth Hendren, and Yashi Joshi. Good morning.
Good morning. Good morning, Chair Dingra, Ranking Member Holy, and members of the committee. Thank you for the opportunity to testify. My name is Janet Helson. I'm a King County Superior Court judge. I'm appearing before you today to urge you in the strongest terms to reject 1620 as it passed out of the House and to reinstate the original bill. Before becoming a judge, I spent 23 years practicing family law with Columbia Legal Services and then in private practice. In both places, my practice focused on representing domestic violence survivors and parents protecting children from abuse. I have spent over 3 years in coalition with others, including many domestic violence and child advocates, working on the original version of 1620. Its passage is critical for families and children of this state. It provides a much needed roadmap, and really our primary goal was to make a clearer, more readable, more accessible law But the version you have before you would have terrible consequences and needs to be stopped. Unfortunately, the bill as it passed out of the House will make the law far less clear and extremely confusing. It eliminates many important protections for domestic violence survivors. It removes necessary provisions. In my view, one of the things that is wrongly removed is abusive use of conflict. It adds many new undefined terms. In many places, it takes us back decades in terms of the language and the law referring to things like mutual domestic violence and custody when we haven't used those terms for decades. I can't go into all the details. I commend you to Elizabeth Hendren's detailed written analysis. Supporters of the current version have advanced a false narrative that this bill pits domestic violence survivors against judges and judicial officers. That is not true. Domestic violence advocates and survivors, many of whom you will hear from, were part of the process. They oppose the current version and they support the original 1620. The original bill was the result of collaboration over several years with many voices at the table. The current version was not. Another false claim is that the original bill vastly increases judicial discretion. To the contrary, the original 1620 offers judges more guidance, requires more findings, and creates clearer definitions. There is no doubt that judges sometimes make mistakes, and the supporters you're hearing from clearly have had difficult and terrible experiences in the courts. But the answer is not to pass this terrible version, which will make the law even more difficult to read and apply, nor is it to leave the flawed existing law in place. Don't let the experiences of a few derail needed protections for Washington families and children. Please stop this version and reinstate the original. Don't fall prey to false narratives. Thank you for your consideration. I welcome any questions.
Thank you so much, Judge. Go ahead, Elizabeth.
Good morning. Excuse me, Chair Dingra and committee members. My name is Elizabeth Hendren, and I'm an attorney with Sexual Violence Law Center, a statewide nonprofit law firm that provides free legal assistance and representation to survivors of sexual and gender-based violence. We are testifying con today because we are opposed to the Stryker Amendment version of 1620 before you. I have represented survivors in their family law proceedings for nearly 13 years. I have also personally experienced this statute as a parent litigant with a parenting plan from 2020 and as a trial witness. And I experienced the Oregon equivalent as a minor child whose mother struggled with addiction and mental health issues after sexual abuse. The current statute is in desperate need of change. And for that reason, SVLC, along with our statewide coalition of survivors, advocates, attorneys, and judges, has been actively involved in working to clarify and modernize it for the past 2 years. Despite that, we cannot support this version of the bill. It is regressive and makes protections for survivors and children even worse. There are more problems in the Stryker bill than I have time to testify here to, but one concerning aspect is the codification of mutual abuse. This committee recently heard, and the Senate subsequently passed, HB 5202 concerning protection orders, and I want to thank you, Senator Solomon, for bringing that. Part of that bill is restoring the legislative findings in place since 1992 that mutual orders and domestic violence protection orders are disfavored. Quote, mutual protection orders label both parties as violent and treat both as being equally at fault. Batters conclude that the violence is excusable or provoked, and victims are confused and stigmatized. Enforcement may be ineffective, and mutual orders may be used in other proceedings as evidence that the victim is equally at fault. It is so tempting in abusive family dynamics to not want to have to take a side. And sometimes judges don't want to take a side. That's why we've asked for that language. But when we don't take a side, neutrality helps the abuse to continue. This Stryker walks courts through how to not take a side when there's domestic violence. Courts can just throw up their hands and label both sides as a problem. Written findings will allow courts to justify years and sometimes decades of abuse if a survivor has ever, at any point, cracked from the pressure. I want to address some of the questions that came up before since I had time. To be clear, abusive use of conflict has been removed from this version of the bill. It is not moved to 187. Those are on pages 28 through 29. It has been completely removed. I also want to be clear that abusive use of conflict includes abusive litigation, but is more expansive than abusive litigation, so it is still not covered. This version doesn't cover false reports to CPS and other abusive systems. I see that I'm clear with time. I'm going to send more written testimony, but I want to thank you all, and I'm available for any questions.
Thank you so much, Elizabeth. Go ahead, young man.
Madam Chair and distinguished committee members. My name is Yash Joshi, and I'm an 8th grade student at Pacific Cascade Middle School in Issaquah School District. I'm here today to express my other opinion with this version of HB 1620 Striker, which not only mentions physical abuse, but not any other type of abuse, including but not limited to emotional abuse and verbal abuse. As someone currently navigating a difficult custody battle, I've experienced firsthand how children often lack proper representation and feel powerless in decisions that profoundly impact their lives. While this bill's focus on domestic violence is critical, it is equally important to acknowledge that severe emotional and verbal abuse can be just as damaging. Through conversations with many of my peers, I've come to understand that the deep and lasting impact of these forms of abuse. To summarize, I have another opinion on HB 1620 Striker, and I believe child custody decisions should involve both the child and the judge, ensuring the child's best interests. Thank you for your time and attention today, and I'm happy to answer any questions you may have.
Thank you so much. Sarah Solomon has a question.
It must be very intimidating to come up and testify in front of a bunch of adults with suits. And I just want to say you're very brave. Your testimony was fantastic. I'll remember that.
Thank you.
Thank you so much. Next, we have Ruthie Sanchez, Kimberly Perez, and Dana Tingy. And it appears that even though Ruthie signed in person, she's remote. So Kimberly Perez and Dana Tingy, please come up, introduce yourself and begin. And after they're done, Ruthie, you can actually, since you're online, Ruthie, why don't you unmute and begin while we wait for the other two to walk up?
Yeah, can you hear me okay?
Yes, we can.
Okay, wonderful. I'll begin. Good morning, Madam Chair and members of the committee. My name is Ruth Sanchez. I'm here on behalf of another who would like to remain anonymous. Okay, I'll start. 10 years ago, I escaped an abusive marriage, thinking the nightmare was over, but my abuser found a new weapon, the family court system. For a decade, I've endured relentless litigation, draining my finances and emotional strength, all to protect my children. Courts too often fail to recognize post-separation abuse and coercive control, allowing abusers to manipulate the system at the expense of the safe parent and children. Section 11 of this bill defines abusive litigation, setting clear guidelines to prevent survivors from being dragged into endless battles designed to exhaust them financially and emotionally. HB 1620 also ensures courts to prioritize the safety of abuse, the children, and the survivor by considering domestic violence as a coercive control in custody decisions. It closes legal loopholes and allows abusers to weaponize courts and forces accountability to reunification programs that too often place children back into the hands of their abusers. No child should be forced into the care of someone they fear. It's close to my heart. My friends and family have had to endure this, so that's a side note. This bill is about justice, protection, and ending cycles of abuse, and I urge lawmakers to pass HB 1620 because family court should be safeguard and not endanger our children. Thank you.
Thank you so much. Good morning. Go ahead.
Hi, good morning, Chair Dingra and members of this committee. Thank you for hearing me today. I'm shocked if you looked at how many people have signed in on this bill. This is clearly something very serious. I have like 3 versions written to tell you, but instead I'm going to just talk to you. I know we all mean well, right? No one wants children hurt. We don't want abuse to happen because we're all good people here. It's also very difficult to fathom that someone behind closed doors might injure, harm, and abuse their family because you wouldn't do that, right? Many times that happens with the judges we appear in front of, the lawyers we hire, the professionals whose livelihood depends on well, basically referrals for family court. I have a lot to say. You've seen me around. I am a mom. I'm a survivor of domestic violence. I'm a survivor of family court. You will hear a lot of testimony. You have called in national people that strip children from their parents and take them to camps out of state. Why are they signing on in Washington state? Because we have a problem. Please let us be heard. We are used to being silenced by those who tell us what we need. We don't have lobbyists. We are moms trying to protect our children. I can give you example after example. It's not right. It's not fair. We worked so hard on this striker. I'm so proud of Representative Taylor bringing this bill forward and working together hours and hours, bipartisan. These are children. These are survivors of domestic violence. Read this striker. It is not what the judges say. It is what the judges want it to be when they want it to be that. I did love my judges. They did great. If only my judges could be in every single courtroom. Please meet with us. Please do not have your next meeting where you talk about this in 2 days. Give us a chance to talk to you, please, instead of those that are telling you what we need. Thank you for hearing me today. I'd be open to any questions or any future meetings. And there's many other survivors that would like to speak with you. I know you're very busy. Thank you for your hard work.
Thank you so much. Another call for Kimberly Perez, who's not present. Okay. We will now go to our online testifiers, Chandra Iffy, Judge Kristen Ferreira, and Sally Wynn. Either would be great. Good morning.
Good morning, Chair Dingra and committee members. My name is Chandra Iffy, and I am a survivor parent who has had a parenting plan with 191 restrictions. I ask that the committee vote to restore the bill to the original version that came out of the House Civil Rights and Judiciary. My child was conceived due to non-consensual sexual contact while I was sleeping and unconscious. I was unaware that the sexual assault had occurred and presumed that I was pregnant with the child of the person that I was dating at the time and with whom I had a consensual sexual relationship. It was not until almost 3 years later that an investigation by the King County Prosecuting Attorney's Office led to the discovery of the paternity of my child through a court-ordered DNA test. I was then forced by the court to interact with my rapist via court and in person for visits. The impact on my mental health was devastating and triggered a severe complex post-traumatic stress reaction and a mental health event. Although it receded quickly, the court treated my mental health issue as the same and actually more serious than the history of domestic violence and sexual assault. The court placed my child with the other parent, and less than a year afterward, the other parent was subsequently arrested and charged with assault and domestic violence against me, and my child was hospitalized due to neglect by the other parent. We went into trial with the understanding that the court would consider sexual assault and domestic violence. The court made no findings on these issues at all, despite the fact that I presented evidence. The judge only made findings against me regarding my mental health event. Under the original version of HB 1620, even if the court did not make findings of domestic violence and sexual assault, the court would have had to explain why it chose not to, despite the evidence I submitted. Please restore the original language to HB 1620, which provides clearer instructions to courts and in turn keeps children and survivors safe. Thank you for your time.
Thank you so much. Judge Ferreira.
Good morning, Chair Dingra, Ranking Member Holey, and members of the committee. I am Judge Kristen Ferreira, a Chelan County Superior Court judge, and I'm appearing before you today on behalf of the Superior Court Judges Association, of which I'm president, in opposition to 1620 as it passed out of the House with the striker, and asking you to please reinstate and pass the original bill. We oppose the bill as it stands because of the striker and the harm that it will cause if passed. However, we urge you to pass the bill as originally drafted and supported by the SCJA. I've been a Superior Court judge for over 7 years. Prior to becoming a judge, my practice included family law and including representing victims of domestic violence. In Chelan County, the judges handle nearly all of the domestic violence and self-represented litigant family law cases. I have presided over hundreds, if not thousands, of family law hearings and trials. These cases are complicated and no two cases are the same. This law needs to be fixed. All of the people who've shared stories with you with bad experiences in court have had bad experiences under the current law. We acknowledge that the current statute does not provide enough guidance or requirements for judges in family law cases, which leads to some problematic outcomes. This has been our top priority as an association because we know how important it is to fix this law and create a roadmap for judges and litigants. Most of our judges haven't practiced family law before coming to the bench, and many judges are very new to the bench. This bill, as originally drafted, provides necessary guidelines and requires written findings to provide greater assurance that the judges will follow the law and properly protect children while honoring parents' rights. The striker, which is now the current bill, destroys our efforts to fix the law, is a step backwards, and would instead create confusion and more problematic outcomes in family law cases that would be harmful to children and families. I heard the comments about abusive use of conflict and it being weaponized in certain family law cases. It is awful to hear stories where this has occurred. However, I can tell you that in our county and many other counties, the majority of our family law litigants do not have the ability to pay for lawyers, let alone lawyers that are utilizing these terrible tactics. And it's concerning to remove these protections in the law because it has been misused by a few. Please do not let bad facts create bad law. The solution is not to remove abusive use of conflict from the statute, but to provide a clear definition to properly address the problem. Additionally, judicial education is a strong counter to any issues related to its application. I can assure you that abusive use of conflict is a real problem. It is often used by abusers to continue their abuse against the other parent, and it's also very harmful to children. Thanks to the legislature, last year we received additional funding for much needed judicial training specific to family law and domestic violence. We utilized those funds to put on 2 trainings, one in November and one in June, and then another training at spring conference that's coming up soon to provide on the topics of parenting plans and domestic violence. We are committed to proper judicial education in the areas of family law, domestic violence, and trauma-informed practices. And again, for the reasons stated, we request you don't pass this bill out of committee as written with the striker, but instead pass the original bill. Thank you for the opportunity to testify today.
Thank you. Senator Fortunato does have a question.
Thank you, Madam Chair. So one of my concerns is not that judges don't have enough discretion, it's that they actually have too much discretion. In a case I am very intimately aware of, a judge simply said, I don't want to see any evidence. Now, how in the world can you present your case when the judge starts off the conversation by saying, I don't want to see any evidence? And then when you do present the evidence by experts, people that are nationally recognized, the judge goes, I just don't believe that. And then on top of that, when you have a situation where the judge fails to recognize that in this case, the woman goes through 7 years of abuse, obviously there's a mental effect from that. And the judge fails to recognize that and just says, well, you know, your behavior here clearly indicates that you're not, you haven't had any ill effects. And the other side says, murder-suicide might be my best option, and admits to saying that. And the judge makes the determination that he was just joking. Now, I don't know how she knows that, but that's a serious thing. And that's one of the things that really seriously concerns me. And how did the Judges Association address that when they just go, it's my discretion?
Yeah, that's a good question. And certainly we've heard stories. I mean, that's troubling to hear that. It's hard to say for certain unless, having everything. I'm just taking the facts as you're saying it. It's really concerning. And we've talked about how we can best address those types of situations. We don't always hear all the bad experiences that people have. But one of the best ways that we can address that is by making sure that each and every judge has proper education. I will say, too, the way you're describing that, some of that goes way beyond discretion. I mean, if that were to go up on appeal, if a judge says, I'm not going to hear any evidence, that I think that exceeds the discretion issue. But we are very committed to addressing these problems. And I'm not going to pretend like every single judge is perfect on every single day. And it's really unfortunate to hear that story. That absolutely, that kind of a situation is an outlier. But we are committed to making sure that our judges are following the law and are properly educated on these issues to avoid those types of situations.
Thank you.
And Judge, if I may just follow up, it appears under the original bill, the judges are now required to enter written findings of fact. And to me, that reads very much as providing greater guardrails around judges' discretion and then creating a record upon which appeals can be filed so that it is clear what the courts or the judges are considering when making their rulings. Would you agree that that does indeed create guardrails around judicial discretion?
Absolutely. I think, first of all, for the judges to say, please require us to make written findings, that's a big deal for us to say that because that takes more time. It makes us, written findings are definitely more time consuming. It makes us sit and walk through the statute and the process and the facts in a way that's incredibly methodical to make sure that we're following the law. And so I agree with you that absolutely resolves some of these issues because there's no way some of these stories I'm hearing would have been able to happen in that way if written findings would have been required.
Thank you so much. The third person on this panel is Sally Wynn. Please do unmute and begin.
Thank you, Chair Dinger and members of the committee. My name is Sally Wynn. I am an attorney and the Director of Legal Services at YWCA Spokane, the largest DV service agency on the eastern side of the state. Every day, my legal team helps survivors of domestic violence navigate the family law system in Washington. Last year, my attorneys handled over 400 family law cases alone. I am here today to strongly oppose the amended version of Bill 1620. Survivors without representation need clear, accessible process. In our state, approximately 65% operate without attorneys, over 50% here in Spokane County alone. These amendments make it even more difficult, removing key protections like abusive use of conflict and creating new barriers. Without these safeguards, survivors face a more confusing, more adversarial system that can be weaponized against them. Going to court is not always safe for survivors. Many seek mediation, informal agreements, or community-based support to protect themselves and their family. The original bill recognized that they know what is safest for themselves and their family. The amended version does not. Instead, it forces more survivors into courtrooms where their abusers are and their trauma can be used against them. All survivors aren't the same. The original bill considered those who have been criminalized for self-defense or coercion. These amendments do the opposite. They codify mutual abuse, a dangerous and flawed concept that ignores the power and control dynamics in abusive relationships. Courts could now dismiss the impact of abuse, punishing survivors instead of protecting them. I think of one specific survivor I worked with. She finally fled after years of violence, only to have her abuser repeatedly drag her into court for modifications to the parenting plan, using the legal system as a weapon of abuse, even after she'd escaped. Under these amendments, a judge could have ignored the documented harm she endured, even placing her children in danger. That's not justice. I urge you, reject these amendments. Please restore the original protections of the bill. Survivors deserve a system that prioritizes their safety and fairness, not one that re-traumatizes them. I'm happy to answer questions. Thank you.
Thank you so much. Our next panel is going to be Evangeline Stratton, Joya Goodhue, and Lindsay Laspisa. I think all three are in person. Actually, I see only two coming up. We'll just double check to make sure none are remote. None are remote. Please. Oh, I see all three now. Thank you. Good morning.
Good morning, Chair Dingra, members of the committee. My name is Evangeline Stratton. I'm an attorney, former advocate, working with survivors of gender-based violence for over 20 years. focusing on litigation on behalf of survivors relating to the underlying statute that we're here talking about today at both the trial and appellate levels. I'm here today to ask you to support engrossed substitute House Bill 1620, not simply because you may see me as a subject matter expert. While I am able to and happy to answer any questions about the language in this newest version of the bill, more importantly, for the first time that I've spent working in this field, I'm standing shoulder to shoulder with survivors. I'm privileged to be invited into a grassroots advocacy movement with these moms who have found each other through peer support. I don't hold a professional position at this time. I'm not in a position of power at a professional association or coalition or center. I do not presume to speak for the survivors here today. You will hear directly from them about their lived experience of abuse, a failing family court system and laws. Please listen. They are not bad facts. They are not outliers. We are now working together to improve protections that exist in our state in custody decisions for survivors of abuse and their children. These improvements are reflected in ESHB 1620. Contrary to other testimony, this is not a terrible version of this bill of changes to the 191 statute. This bill's language is rooted in the spirit and the language of the National Council of Juvenile and Family Court Judges Model Code on Domestic and Family Violence. And it's inspired as well by the best parts of our current statute, the best parts of the original bill, and most importantly, by the real stories of the survivors that you will hear from today. Please vote yes.
Thank you. Go ahead.
Thank you, Madam Chair Dingra and members of the committee. My name is Joya Goodhue, and I'm here to strongly support ESHB 1620, which is based on the nationally adopted Cadence Law, because our family court system is failing to protect children from abuse and is placing them in harm's way. In 2022, my child was granted a temporary DVPO to protect her from her other parent. But when I sought permanent protection for my daughter, my co-parent's rebuttal was to allege parental alienation and abusive use of conflict against me. These are two unvalidated pseudoscience claims that courts use against protective parents. Those allegations enabled a parenting plan modification case to be opened after 8 years after our divorce was final. The DVPO commissioner violated Washington state law on DVPOs by dismissing my child's DVPO, ignoring the other party's past arrests for DV, and forcing me to pay his legal fees. Oh, sorry, I just lost my place. This placed my child in harm's way. I was held in contempt and ordered to pay the other party's legal fees when my child left forced contact visits with her father out of her fear of him after the DVPO was dismissed. HB 1620 section 1(5) ensures that protective parents are not punished for reporting abuse. It prohibits courts from using false claims of alienation or abusive use of conflict to strip custody from safe parents. For over 2 years, I was forced into court-ordered evaluations, reunification therapists, guardians ad litem, parenting coordinators, the whole cottage industry that drains protective parents financially. My child was in limbo for 2 years, terrified of being forced into the other party's custody. This caused severe psychological harm to her. ESHB 1620, section 1(9) restricts judicial discretion, and they don't like that. that allows courts to ignore documented abuse and place children with abusers. It creates a rebuttal presumption against custody for abusive parents and ensures judges make specific written findings before granting them parenting time. This is what keeps kids safe and healthy. Family courts are using their discretion to punish safe parents for protecting their children by switching custody from the protective parent to the other parent. Now, this happens more often when the protective parent is the mother. The United Nations has condemned the gendered use of alienation as a rebuttal to DV as violence against women. ESHB 1620 ensures that domestic violence and child abuse are treated as crimes, not custody disputes. I urge you to pass this bill that will protect children. Thank you. I'm open to questions.
Thank you so much. Go ahead.
Good morning, Madam Chair and committee members. My name is Lindsay Laspisa, and I am in strong support of ESHB 1620. I have been entrenched with the family court system since 2018, fighting for the safety of my 4 children, ages 16, 13, 10, and 8. In our case, the Snohomish County Courts egregiously abused its discretion, disregarding compelling and clear evidence of abuse presented by CPS, a child psychologist, school counselors, and school administrators. Despite all of this, the judge in our case shockingly reversed custody, placing my 4 children with their abuser. I want you to imagine what that moment felt like for them. Imagine the fear in their eyes. Imagine their little hands as they trembled because they wanted to stay safe, only to be forced into the arms of the very person they were terrified of. Imagine their cries being silenced by a system that refused to listen to them. If ESHB 1620 had been in effect, it would have spared my children from the ongoing abuse and trauma that they currently are enduring. Our judge was clearly not trained to see the signs of abuse. This bill would ensure judges receive vital training on recognizing lethality risks, understanding adverse childhood experiences, otherwise known as ACEs, and applying trauma-informed decision-making, key factors in determining protection and safety for children. These are not abstract concepts. These are life-altering, life-saving interventions that could prevent the irreversible harm my children continue to experience today. ESHB 1620 is not just another piece of legislation. It's a lifeline for children who are vulnerable and for communities that need to know we will not stand by while our children are failed by the very system that is meant to protect them. This bill is an urgent call to action, a tool that can empower judges to make informed, compassionate decisions that prioritize the safety and well-being of children above all else. The judge who testified before, I don't remember her name, said not to fall for our false narrative. I only wonder how she would feel if it was her children that were being constantly abused. Family court needs ESHB 1620. Our children deserve nothing less than a system that places their safety first. It's time to ensure that no child ever has to suffer the way that my children still do today. Thank you.
Thank you so much. Senator Fortunato?
Thank you, Madam Chair. So, Evangeline, do you have examples of areas where judges have abused their discretion? I mean, even if you give us numbers or situations that you're aware of?
Should we raise our hands?
Well, I would start off by saying from an appellate attorney perspective that the vast majority of decisions that are made in family court fall within that standard of review. So most things, child support, whether to grant a protection order or not, whether to make a finding that there has been abuse for purposes of a parenting plan, all fall currently under an abuse of discretion standard. The only thing that changes that is if the statute in black and white says that judicial officers must do other things, right? They must consider certain factors. They must make express written findings. If those are in the statute and that's not followed, that gives a litigant an ability to ask for review if that has not occurred.
Okay, but
thank you.
Are you aware?
Senator Fortunato, I think we're going to have to take that offline. Okay, our next panel is Don Sidney, Debbie Gonzalez, Bogdan Lento, and we're going to try to get to the panel after that. So you're prepared is Heidi Padilla, Amy Annette, and Brandon Padilla. Go ahead on the remote testifiers. Dawn Sidney, can we have you unmute and begin?
Good morning. My name is Dawn Sidney. I've been practicing family law in Washington for 14 years. I have a solo family law practice where I represent survivors in DVPOs and family law cases exclusively. I do not ever represent perpetrators. Prior to practicing law in Washington, I worked in public policy with nonprofits, first in Missouri, only because I went to law school there, and later in Washington, D.C., advocating for survivors of domestic violence, including children. I've spent 35 years working in gender-based violence. My comments are focused on just one part of the bill, abuse of use of conflict. For all other issues, I refer you to the excellent legal analysis by Elizabeth Hendren from the Sexual Violence Law Center, which I fully support as an attorney working with survivors in the legal system every day. Currently, RCW 2609191 3E provides for a court to impose limitations on a parent with respect to residential time, decision-making, and the dispute resolution process if a parent engages in abuse of use of conflict. This term is only generally defined in the current statute. It is from this that abusers have been able to use abuse of use of conflict as a weapon against survivors. As this body did with RCW 7.105 a few years ago, HB 1620, standing alone without the amendment, provides a definition, examples, and context regarding abuse of use of conflict, giving it much needed clarity and guidance. Abuse of use of conflict findings are critical for survivors. For example, a client of mine came to me after she was not able to obtain a DVPO representing herself. In the family law case, we were only able to get limitations against the perpetrator due to abuse of use of conflict. The court made a finding that the parent engaged in abuse of use of conflict only after my client and the children had to endure many CPS visits and interviews due to the perpetrator making repeated false allegations that my client was abusing her children. The striker completely removes abuse of use of conflict as a basis for the court's consideration in limiting an abusive parent's behavior. This is significantly more harmful to survivors than even the current statute. Critical to survivors is to have abuse of use of conflict included as a basis for limitations in parenting plans and to have that term defined and given context as done in HB 1620 standing alone. Based on all my legal and advocacy experience with survivors over the last 34 years, the amendment needs to be defeated and HB 1620 supported as originally passed as in the best interest of survivors. Thank you, and I'm happy to answer any questions.
Thank you so much. Next is Debbie Gonzalez.
Good morning. My name is Deborah Gonzalez Long, and I'm a legal advocate here in Central Washington and have worked in the field for 20 years. Today, I'm asking that you do not pass Bill 1620 with the amended language. The original bill provided a clear framework for unrepresented survivors. It is already hard for our marginalized rural communities to even get access to the court. In its current form, this bill amended language introduces unclear language that is difficult to understand and would disproportionately impact those in the rural areas with limited legal resources and those from ethnic communities facing language and cultural barriers. We need clarity, not further confusion. The amended language also pushes a court-only approach, which takes choice away from survivors. This especially impacts rural areas where access to courts is limited and in communities where cultural beliefs may discourage formal legal processes. We need options that prioritize safety, not forced litigation. The original bill recognized the complexities faced by all survivors, including those criminalized. A one-size-fits-all approach fails marginalized survivors, particularly those in rural communities with limited support services and those from ethnic backgrounds facing systematic discrimination. The original bill's language, especially regarding abusive use of conflict, is vital for these cases. The amendments to this bill weaken vital protections for the most vulnerable survivors, including those in the rural communities and diverse ethnicities. Please do not pass these amendments and move the bill forward in its original form. Thank you.
Thank you so much. And then we have Bogdan Lendl.
Hello, Madam Chair and members of committee. My name is Bogdan Lendl. I'm here today to strongly oppose House Bill 1620 because it's dangerous for parents, harmful to children, and a violation of fundamental fairness. This bill would strip parents of their parental rights based on mere allegations rather than proven facts. And the Center for Prosecutor Integrity did a study, and in 62% of cases, females were falsely reporting abuse against the males. And usually the false allegation was made during a child custody dispute to win an upper hand. And the survey found that females or mothers are filing double amount of false reports against fathers versus vice versa. And per courts.wa.gov website, mothers receive custody more than 75% of the time. So with those three statistics in mind, this HB 1620 assumes that fathers are guilty until proven innocent, and hence full control to one parent based on false accusation alone. And so I want to say why this bill is dangerous for parents and children. Number one, it encourages false allegation. This bill allows mother to gain full custody simply by accusing father of abuse, even if there is no real evidence. The standard of proof is shockingly low. A preponderance of evidence means that if something is only 51% likely to be true, father can lose his children. And this invites misuse by parents looking to control custody battles and making it easier to alienate fathers from the children. Number two, it automatically punishes accused fathers. Under this bill, the father is accused, even if it's falsely, he loses joint custody and decision-making rights over his children. He may only be allowed to supervise visits, and he must pay for it, which is a financial burden that most fathers cannot afford. Number three is it destroys families and hurts children. Research shows that children need both parents to thrive, and this bill makes it far too easy for one parent to erase the other, leading to parental alienation and emotional harm to the children. Courts will be forced to assume that if the child resists seeing their father, it's because of the abuse, not because of the other parent manipulating them, which is a lot of cases that's what happens. Number four, it limits father's rights to the children. If the father challenges these unfair rulings, he can be accused of abusive litigation and be barred from trying to get his children back. And fathers should have rights to defend themselves without being silenced. So in conclusion, this House Bill 1620 violates basic principles of justice, that a person is innocent until proven guilty. It removes fathers from children's lives without proper evidence, due process, and fair chance to defend themselves. I urge you to vote no on the 1620 bill, and no on the original, and no on the current. Thank you very much.
Thank you. We have time for one last panel. It'll have to be quick. It's Heidi Padilla, Amy Annette, and is there Brandon Padilla here?
Recording in progress.
Okay. Morning.
Would you like to hear from
Yes, please begin.
Thank you, Madam Chair and members of the committee. My name is Amy Annette, formerly Amy Annette Peters, and I strongly support the Stryker Bill 1620. My divorce began in 2021, and like many women and children caught in the trap of the family court system, the nightmare is ongoing and likely will continue until my children turn 18 and are finally free of the family court system. The family court system is corrupt through and through. Washington is a no-fault divorce state. Family court has the legal discretion to not hold an abusive parent accountable for their behavior because the court, by legal definition, cannot find fault in a divorce. This begs the question, how can a divorce be brought before the court for adjudication when, by definition, a divorce should not be litigated or considered a lawsuit when no fault can be found? Additionally, it is a conflict of interest for attorneys to practice family law when their livelihoods and job security depend on creating conflict to increase their billable hours and separate their clients from the very things that sustain their well-being, namely their families and their finances. Simply put, family law deals in child trafficking,